We are at the Federal Appeals Courthouse in Lower Manhattan. You're from Bravest for Choice. We just came out of a hearing in the Garland versus FDNY case. How many plaintiffs actually were in this case? Do you know roughly?
I believe we had about 7. I think the number might have been 78. We had it's a considerable number of plaintiffs. It's well over 50, and those members are FDNY members from different job titles. So we have officers in lieutenant's rank. We also have, I believe we have a captain in there as well. Also, the firefighter rank is highly represented, and then we also have members of Local 2507, I believe it is. It's so the DC 37 aspect of this case, those are EMS members, EMTs and paramedics that are also FDNY employees under a separate union.
Okay, and I didn't introduce you properly. You're from Bravest for Choice.
Yes.
And tell us a little bit about that organization and what its connection is to
Sure,
this
I'm
case.
Matt Connor from Brave. I'm here just to help, just to represent Bravest for Choice in this litigation. This is litigation that we organized early on, immediately following the mandate. Austin Graff was one of the few lawyers that stepped up to the plate and came out to represent New York City workers that were seeking to challenge the mandatory vaccination of public employees. Our group was largely firefighters and also fire officers, and like I said, some EMS members, EMTs and paramedics as well. And in the beginning, it was very uncertain as to what was going to happen. One of the important things about this case is that many of us didn't know what was going to happen to us when we chose to stand by our convictions and not comply with the mandate. And we were uncertain as to whether or not we'd be terminated immediately, or if there would be some sort of period where we'd be able to be given due process after the deadline of the mandate. And it became very clear that there was no intention by the city to provide us due process. But in the initial temporary restraining order hearing for this case in the lower court, the district court, we did learn through that proceeding that the city was questioned as to whether the members would be terminated immediately following the deadline. And that was the first information that we had, that we would indeed not be terminated and that we would have the opportunity to submit an appeal through the religious accommodations or medical exemption process, through the reasonable accommodation process in general. But as was, this issue was spoken to today, many members objected and did not want to seek an accommodation. They just felt that this mandate was illegal from the outset, and they were not going to comply with it. And there was no process for us to challenge that. We didn't know what was going to happen to us. Very uncertain as to if we would actually be terminated or not. But a lot of people were convicted, had this conviction that they were not going to comply with the mandate, and we felt like there was nowhere to go, and the litigation was one of the avenues that we chose. We organized quickly and were able to challenge via this litigation. So that we were thankful for Austin and his efforts, because we really were flying in the dark with this whole process. There was no avenue for us to challenge it, through our actual agencies at the agency level.
So you were saying there are nearly 80 people who are plaintiffs in this appeal, in this case. What's happening with those people now? How are people? The mandate came out a couple of years ago. Right. This is still an unresolved issue. What is happening with all of those people? It's a
mixed bag, right? So there's some people that ended up seeking a reasonable accommodation, and there was a very slim number of those people that were granted. For example, I was in part of a group that fought for a medical exemption, and we were granted provisional reasonable accommodations based on that action. That was a long, hard fight in and of itself. That's separate from this litigation today. But so some of us were able to fight our way back to work through that process. We still have members that did not comply with the mandate, that were actually terminated, that are still not back to work, but they're still ready, willing, and able to work and serve the city of New York, that are still being withheld from work because they're being coerced to sign a waiver of their legal rights, their civil service rights. And so there's a lot of people are in different different positions, 2 years out in this, and we're here to stand with all of them, whatever path they chose in terms of how they chose to challenge the mandate. Everyone deserves the chance to come back to their employment that they rightfully earned, and that's what today is about: is a deprivation of our constitutional rights to our property, our pay, and essentially our paycheck and our civil service position that we earned.
Okay, well, we had the oral arguments today. Sometimes these decisions come down very quickly, in a week or so,
and we hope it does.
We wait for
we felt
months.
that today you heard the court. There was a real tide shift today in terms of the court actually hearing some of the meat and potatoes of what actually happened, and questioning the city on the way that this was all perpetrated. And we hope that this court does see what actually happened here and comes to a quick decision. Very reasonable. Any reasonable and fair judge, in my opinion, can't look at what actually happened in New York City and not see that this was a complete, it's a sham, as it was referred to in the court today. It was a sham, and it will be exposed as such through efforts like this.